Hello and welcome to the Law Office of Kenneth Vercammen. In this edition we look at the sale of a house in a probate matter. Now, let's say if there's a will, the executor properly has the appointment to meet with the surrogate. They get their letters, testamentary, we call them shorts, and thereafter what the executor typically does is they work with their attorney to have the New Jersey estate tax filed if it's an estate over $675,000. If it's under, we still have to file the New Jersey inheritance tax, even if there's no tax if it's going to children, spouse, or grandchildren, but we still need to file that return so we can get tax waivers. The attorney will then, once it's filed and gets the waivers back, file the waiver with the county clerk. And obviously, it's each county where the property is located. Let's see, the executor then selects a realtor to work with. I always recommend to the executors make sure the listing says as is and any contract says as is. Don't wait till after the contract's signed to try to add in later on. Estate sale as is. The title company for the buyers is going to make the executor fill out an estate questionnaire and certify that the estate's under $675,000. And there's also some other paperwork that has to be provided. And so it's more work when there's an estate, but not overly complicated. For other information on the sale of a house in a probate matter, visit website njlaws.com. Obviously, your attorney will need to prepare the deed, the affidavit of title, the seller's residency certification, and there's also a some other paperwork that's prepared. Let's see. Sometimes there's negotiations on the contract, but oftentimes when we're selling a house in an estate, we say, listen, either you want it or you don't want it after they get their home inspection. The seller's dead and the executor typically isn't going to go on the roof and fix holes. For representation in probate matters, contact Ken Vercammen's office at 732-572-0500. Thank you and good luck.